Good morning, everybody. This is Judith from EIT Urban Mobility. Welcome to this webinar. I am here based in the headquarters in Barcelona, and I am responsible for managing the targeted call, which is the call through, well, that you are interested in applying for. This is the third webinar in a row. So Maya, if you wouldn't mind going to the next slide. So this is the third webinar in a row. We had the first one last week, Tuesday, in which we explain you the general call information, how to apply, what are the topics about, the evaluation criteria, so everything you need to know to apply successfully. The day after, Arthur explained you about the financial sustainability mechanism, in other words, the return of investment that we expect from the project we finance. And today we are going to talk to about something that is related, of course, to the financial sustainability. We have a lot of importance in the commercial side of our project, so not just the impact, but also the commercial potentials of the project, the products and the services that we fund. And therefore, intellectual property is crucial. Please be aware that this webinar is being recorded. The good thing is that all of these three webinars you are able to find on the official call webpage. So I would like to introduce you now to the one who is actually going to lead this call, which is Maya. Luckily, we have an internal IP expert as part of EIT Urban Mobility. So Maya, please go ahead with the rest of the presentation.
Hello everyone. Can you hear me well?
All good.
Yeah, great. And the screen also?
Also good.
Awesome. Okay. So yeah, so in this webinar, we will address the topic of intellectual property in the call and in your proposals. And basically, in two blocks of questions. So in the first place, the concept of intellectual property and how to address, how to detect intellectual property elements within your solutions. And how the second block, how do we draft, how do we address intellectual property requirements in the call, and how you should draft your proposal with regards to these requirements. My name is Maya, and I'm a peer legal counsel with over 15 years of professional academic experience in the field of intellectual property, and I support EIT Urban Mobility with innovation projects and startups. Support when we help startups to detect, protect, commercialize their solutions, and as a part of our activities within the exploitation panels and IP box that we have, or IP help desk that we have currently in the mobility. We
Maya, sorry to interrupt you, but I get some people in the Q&A saying that the audio is not very good. So if you try to go a bit closer to the laptop and see if it goes a bit better.
Sure, no problem. Yeah, so when we assist startups through their innovation journey and ensure that they maximize value of their intellectual property solutions. Yeah, so let's start with two blocks of topics. In the first one, we will define the concepts. What do we mean under the concept of IP, together with innovations, inputs, results, and impacts on the Horizon Europe regulation requirements? And the second block, that how do we address IP elements in the proposals? So what do we mean under IP rights, IP protection, the concept of IP landscaping and IP strategy? Also, we'll have some specific examples, good and bad practices. Yeah, so to be a bit poetic in the beginning, this painting can illustrate basically the elements of innovations within the urban movement. Yeah, so innovations together with IP elements, intellectual property elements, um, present invisible threats and that are trying to create these harmonious movement patterns within the city movement. Yeah? So the point is that innovation elements are everywhere, yeah, weaving together all synergy of city. So, but what do we mean under innovation? We all work in innovation, for innovation, but generally speaking, this is a very often used and misused term. If we look at the definition of innovation from regulatory perspective, so we have recently agreed definition for almost 70 countries internationally, approved by World Intellectual Property Organization, EU IPO, and other organizations, ICO. So innovation, basically, that's not necessarily the process, yeah, but the outcome. The outcome when we introduce or apply new or significantly improved projects, services, processes, methods, models, and the most important part of it that all these elements should result in positive changes in economic or social value for stakeholders. So this high-level definition basically focuses on these three elements. Yes, so that's introduction and application of new or improved product, services, processes, and with the result of positive changes. Yeah, so in this context, what do we understand under intellectual property? So we also have a legal definition and the tangible or practical definition of intellectual property in the context of innovations. So under universal, also internationally, globally agreed definition from World Intellectual Property Organization, intellectual property, that's basically the creation of mind in the different fields, industrial, scientific, literary, and artistic fields. And roughly, we can divide intellectual property assets into two blocks, which are industrial property and intellectual property. Yeah, so if we deal with industrial property, we are dealing with inventions, know-how, trade secrets, designs, also brand values, also company reputation, and all related to industry assets. And when we deal with the concept of intellectual property per se, that's basically mostly about artistic works, literary or scientific fields. Also, knowledge and people, not traditional understanding of intellectual property assets, but still they are also considered as intellectual property elements. To understand also the interplay between these two concepts, intellectual property and innovations. So when we are talking about invention, yeah, so it's let's say that intellectual property or patent, it's not only patents, right? So, and patents are not exclusive representative intellectual property rights, but patents cover inventions. Yeah. So, what is invention? Invention is a new, ideally globally new, yeah, solution that can represent as inventive, that has an inventive step, so has an um, extra level um, inventiveness, of innovation, and has industrial applicability, which means that it's not purely theoretical solution, right? But it has its practical application in some industry. that's invention. By contrast, innovation, not to confuse with invention, that's implementation of this invention into the industry, into the bringing it to the market, delivering impact. So, in the meaning that this invention should go through the process of assessment, whether it's basically meeting all the elements of novelty, inventive step, and applicability, bringing it to the market, and delivering impact and value. Yeah, so only through this process, invention can become innovation in the pure sense. that that's why invention not necessarily leads to innovation, right? We have sleeping patterns, we have sleeping inventions never used, right? But only when invention went through this process, innovation process, and can bring impact or value, that's basically can be considered as an innovation. So we all know that the millions of ideas that never made it to the market. So that's why purely ideas never can become innovation. Um, and also intellectual property and intellectual property rights, right? So basically, when we are talking about rights, they are legal tools, or let's say in this illustration, they are shields to protect key assets. So don't confuse inventions with patents, because patents, they are tools to protect inventions. Yeah? The same with other tools like utility models, trade secrets, or trademarks, or copyrights, that they are specific rights, right? Intellectual property rights to protect key intellectual property assets, which can be, you know, design, which can be specific content, trade secret, commercially valuable information, or brand value. We also will address a bit later these elements. Okay, so if we look at intellectual property rights, so they are tools to protect IP and innovations. And of course, since they are legal tools, we do have specific requirements in order to obtain this tool, in order to obtain this monopoly, because generally speaking, these rights has monopoly nature. Yeah? In terms that once an inventor is granted a patent or registered a brand as a trademark, he or she is becoming a monopolist in a specific field, in the meaning that he or she can prevent others, competitors mainly, to do the same in this field. So that's monopoly rights in this sense. Okay, so if we deal with industrial rights, as we said, inventions, industrial designs, or trademarks or brands. So in this context, we deal with registration rights, right? So these rights are granted upon registration. No registration, no rights, no tools for legal protection. No? So corresponding rights. So patents we have for inventions. For inventions can also be covered by other tools, right? So not only patents can cover your invention, which is also often misunderstood. We also have utility models with a bit less, let's say, light protection than patents, but still they also can cover specific inventions. Also, we have trade secrets as an alternative to patenting your invention. But all these rights can be granted with registration, in the meaning that once you have an idea and you decided this idea can be presented as invention, to be considered invention in a legal sense, you must go through the process of patenting. Yeah? So examination, assessing whether your invention is meeting all these necessary requirements of novelty, global novelty, inventive step, and industrial applicability. And also design rights. So if we are dealing with um, representation, or graphical representation, or a design representation of your product, right? So we have specific rights for this also, namely design rights, registered rights. Also, they can be protected by know-how or trade secrets, depending on your business strategy, depending on the specificities of your products and services. Also, trademark rights, trade dress, packaging, they all are commercial intellectual property rights, which can protect branding, goodwill, or exclusivity, or specific elements of your product or brand. So differentiate you on the market and avoid confusion with third party, with your competitors, preventing or delimiting your market reach, so with this brand registration. So all these rights are registered rights, and by contrast, copyrights, which are very, let's say, generally understood as a unique protection for software in Europe at least, but we will talk about this a bit later. But copyright is not necessarily should be registered, right? So if your solution is presented as a software, yeah, so there is no mandatory registration for copyright to protect your software. However, we do have voluntary registration for copyrights for software or other content or other valuable information or commercially valuable information, depending on your strategy also. The rationale behind registration, ownership, right? So the presumption of ownership to justify in the court or to fight with your competitors, saying that you were the first with this software and so forth. The same is actually for database rights. So data is the blood of most of solutions. So also copyright can help, can be as a tool to protect this data. No automatic, no necessarily registered, but in some cases it's highly recommendable to register this. Yeah, and one more point, all these rights are national rights, which means that if there is a registration, this registration works for only specific territory. For example, if you register patent for Spain, it will be valid only in Spain, and your competitors can duplicate you in any other territories. No? So that's the essential question for your IP strategy, to understand the geography and to align basically your IP strategy with your business strategy, whether you need to cover more markets for further expansion, for further commercialization of your product. And normally, as a due diligence or best practice, you must do that in the very initial stage of, presenting your solution. One point, because patent, right to patent anything can be lost. once you disclose anything before registration. So it's also strategic solution. Yeah, so national rights, and if you uh, would like to expand your strategy for several countries, we have possibility to, at least in Europe here, to get the European patent. However, it's not um, that's not kind of international patent, right? So you anyway you need to uh, mm, have this examination in every country in the European Union when you would like to sell your product or service under this patent. Um, so harmonization in this field, in patent field, is still let's say the work in process, and it's not finalized yet. Yeah, so in this case, you must be careful with patenting and deciding this in the very beginning. The same works for design rights and trademark rights, but here we have more freedom to register, let's say, international trademarks or international design rights. We have World Intellectual Property Organization that can cover most countries in the world when you register brand there. And also we have European Union. In other countries have our European Office of Intellectual Property, and they register with European trademarks with the most coverage of all European countries. Yeah, so in this case, for trademarks, branding, and design rights, you can get them. Let's say the large coverage of protecting your brand there. Copyright is also national, yeah, so that's why it's highly recommendable to register in order to protect in most countries. Um, yeah, so why do we need intellectual property rights? So the legislator, basically the rationale, the national rationale behind IP was to, of course, benefiting on both sides, society and innovators. Historically, IPRs uh, were protected as benefiting innovators and to the king, of course. And currently, they also see this narrative of win-win story, right? So benefits to society, to encourage more innovations and creativity. So basically, that's return of investment in your protecting your intellectual property assets and protecting your solutions. So if you invest, so you will get a feedback from that. Building on existing innovation, because once you patent anything, if you decide to go for a patent strategy, you must disclose your solution to the general public, which means that other innovators can access easily public databases and consult your solution and basically build upon and improve. So no secrecy in this case, but you are becoming a monopolist in this sphere, and that's basically the nature of patent, negative monopoly. And in this sense, it's benefiting innovators. So once you are monopolist in this field, you are deciding, you set rules, you got giving licensing, you're not giving licensing. So the rationale is benefiting both society and innovators. The deal is disclosing innovations, open to public, and stimulation innovation. And you get monopoly rights. Of course, the period is limited because that's monopoly and should have limits. That's by a general term, that's 20 years for patents. That's for this period, you should get the most from your solution, because after that, it comes it goes to public domain, and every innovator can use your solution for free and return from investment. Mm. So why do we need intellectual property in Horizon Europe framework? And how do we recognize IP in the project, and how do we manage them? So the interplay between IP innovation, Horizon Europe, and we see that this interplay basically um, is working as a narrow and broader term. So Horizon Europe sets the general rules. We have innovations, once again, journal and IP that's in the middle. That's a very narrow term that uh, that covers only IP assets, so solutions that can be protected by intellectual property rights. Once again, rationale for IP within European framework. So if we look at the citation from the European Commission, investing in research and innovation is investing in our future. So basically, via investing and in protection of your innovation and protection of your solution, um, it's a strategic choice, so that should be part of the strategy. And innovation elements are everywhere. We are sitting in a third floor in this case. However, the IP elements and innovation elements are in all three pillars are presented there. So IP IP, or in other words, results of innovation projects that are the key results of any project from any period. And where can we see the locus of IP? So if we look at this time frame of the project under Horizon Europe 2, so we can see that starts from the very beginning of idea, basically, when you have your solution, when you have your proposal, and you start the project, and you have some expected results of this project. So can be any knowledge, any IP assets, any intangible assets, any data, basically research or general data. That all these elements can be considered as key assets in the project and intellectual property assets. Then management and protection of these results. So during the project, during the lifetime of the project, all the deliverables of results will be managed, and the protection should come together with management. So that's the part of your business strategy, business plan, which should include protection of your key assets. Also, dissemination and communication of results. So this part is also linked to intellectual property elements. Once you disseminate your key solutions, also and results, IP also said that. And of course, innovation. So once you go to the market, this part is also is considered as innovative part, and that's the strongest and most important part of IP commercialization or monetization, when you basically can already give licenses on your solutions, or sell your product together with licensing, or sell the IP itself. So several strategies. And impact. So basically, that's the successful marketed innovation that we are expecting in the whole, and benefits that should be derived from using innovation, any benefits, but scientific, economic, societal, but of course, our focus is commercialization in this case.
Maya,
Yes.
sorry, again, like I just tried to remind you to go a bit closer to the laptop.
Yeah, sure.
So
If I won't dive here in all IP results management details, however, the purpose here is just to illustrate the time frame, the lifetime of development of your IP assets within the project. So once you are starting with the concept of the project or the proposal, yeah, so in this case, you must detect, you must illustrate and present in your proposal key uh, key elements of intellectual property rights, right? So you must explain the solution in terms that um, we have this invention and it is protected by patent, or it will be protected in patent within that project lifetime. You know? So it starts from drafting the proposal and explaining the key results to explain, to expect once we develop the project, once we implement the project, we will have the solution protected via specific IP tools, and the strategy is to monetize these IP assets, key solution in a specific way via licensing, selling, and so on. Yeah, so during the project, it will be reviewed in each stage, and it will be questioned, of course, whether at this stage your solution is protected in a specific way. And by at the end of the project, we have the specific requirement from Horizon Europe regulation that each beneficiary must present mandatory results ownership list, so-called role in terms that you must specify owners of this solution. You must identify protection for this solution, for this result. And of course, it depends on the outcome of this list will affect the final payment. And last but not least, we have post-grant reporting. So in terms that if there is, even if the project is finalized, still we have the obligation, beneficiary have obligation to report on the success of this project on the market, obligation to exploit, commercialize the results of this project. And if no success for 1 year, so there is also obligation to transfer the rights or to showcase these rights on the Horizon results platform, which means that any third party can come and offer support to commercialize these results. So once again, inputs and outputs. So IP can be localized from the beginning as input of the project or background IP. That's basically all solution that you bring to the project. Can be research data, reports, databases, invention of how algorithm and solutions. So during developing this project, you can basically come up with new solutions. And also networks and trained people, they are also considered as IP assets within the project, which can be protected or not. That's another question with which tools it can be protected, but anyway, always knowledge related elements can be considered IP. So inputs during the project, expertise, solution, know-how, and basically funding can be considered as input. Then results as the end of the project can be any solution, for example, SaaS as a logistics solution, which can be impact. Impact is a successful implementation of this solution or improvements of infrastructure of the existing one, and inventions. So when the product with this invention can be put on the market and commercialized. So during your drafting your proposal, you must justify that impact, right? So always 3 elements and the impact from that. basically wider effects of your solution and specific contributions and how you will use these results in industry. And now we are moving to the second block of the question, so which relating to the proposals. How do you protect your solution? What is IP landscaping and how do you draft your strategy relying on examples, good and bad practices? So in the call, if we look closer and the call manual and call requirements, so we can localize IP at least in 3 blocks, specifically at section 3 in call requirements, because the topics itself are drafted in a way that we expect innovative solutions, so IP innovative related solutions as a new projects, components, and improved functionality. So we are dealing here with IP assets, essentially with IP assets relating to the topics. Next, technology readiness level. So the level of your solution that we expect should be close to market, in the meaning that in your proposal, we expect to see that the understanding of the strategy of your commercialization of your main elements of your intangible assets, of your patents, of your invention, of your platform or technology. And of course, we have additional KPIs, which are market and innovation and IP as an additional KPI in this case. Also, section intellectual property, so specific one, when we request IP landscaping protection matter that should correspond to your solutions, to your IP rights, and a commercialization strategy. So how you're going to commercialize, monetize your IP assets. And one more extra KPI that's also FTO analysis, and I will focus on that a bit later. And section 5.2, that's quality evaluation. So basically, this part we explain how your proposal will be evaluated in terms of excellence and impact. And IP elements also play essential role there. In particular, we expect you to illustrate the level of readiness of your solution in terms of protection. Yeah, so whether you conducted specific FTO analysis or research on your competitors in your market, in your niche, whether you have any obstacles to implement your solution, the maturity level of your solution in terms of patent applications, or you already was granted a patent, which is great. Did you protect any branding via trademarks or other tools? So yeah, and always it's a part of strategy, and we will look at that through the lens of evaluators. The rationale behind that, because Horizon Europe requirements, they are clearly set this philosophy of best efforts. Okay, so beneficiaries must implement best efforts to protect, commercialize their IP assets, meaning results of the project. That's basically what money for. Okay, so to give you even more, a bit more motivation to protect your IP related assets, we have this study from EUIPO from last year, and in this context, we can see the relevance of protection of main solutions, especially for startups. So startups that register IP rights, they do have priority in obtaining seeds and early stage financing. So that's all about the trustworthiness of and value of startup and their solutions. Also related to reward of early investors through success, and sale to another company. Yeah, so the attractiveness of your solution directly depends on protection tools or protection strategies that you implement. And one more finding on the exit performance of European startups from last year that registered intellectual property rights like patents, trademarks, designs give a more than twice a high likelihood of successful exit for investors. So not only patents actually play a role here. So don't limit yourself only to patents, even though you have a specific hardware solution to implement into a product and to go to the market. Think broader, think about other instruments that can be applied because definitely you have a platform, definitely you have a database of clients, definitely you have branding. So all these elements can be protected via APRs, intellectual property rights, and give you more visibility, give you more chances to get funding. Innovation value chain. So if we look through the value chain of the innovation process, we can see this process of creation of ideas. So basically that's the meaning of IP landscaping. Okay, so since you create your idea and looking for funding, you are detecting, you are should recognize the main IP elements in your solutions and select which one you are going to focus on mostly and respectively protect. And protection, as we said, could be different. That's umbrella of IP tools, IP rights that can protect your single solution. And once again, don't limit yourself only to patents, because often we hear from our startup that we have only platform, we have no patents, we cannot patent algorithms and so on. So in this context, it's a strategic actually choice. It's a strategic approach to your solution. How, which other tools we can implement to protect our efforts, our intellectual efforts, commercial efforts in developing this solution. And commercialization stage, of course, that's the stage that we expect from you mostly. And that's the transformation of your solution into product and services. And here we expect you to understand the outcome of your solution, the effect, its effect on the market, and how can you monetize the solution IP assets that you have in terms of your role in the market, whether you can license something, whether you can collaborate with competitors. So that's also part of your business and of your strategy. If we look at the example, so of IP landscaping, if we have a technology or product solution, so at least 3 blocks of IP assets can be identified, detected. So first software and hardware, and then brand and reputation. That's the classic general division of any solution that is delivered, let's say. So in software, new technologies or improvements of existing. Yeah, so as we all know, most patents, 90% of patents are granted to improvements, right? Not to absolutely new technologies, but to improvements of existing ones. That's reality. And databases, that's also IP asset. Website, interface, content, so it's also IP asset which can be protected. Hardware, well, that's obvious. Patents can work and help here. New technology and improvements also. Designs, so if patent does not work in your case, hardware can be also protected by designs of some cases. Trade secrets also work everywhere. And brand's reputation, which also comes with almost with all solutions by default. the logos, slogans, marketing materials, designs, company recognition on the market, all these are intellectual property assets that should be protected and defined in your strategy. Which tools can work? So for software, copyright, design rights. Also, we have so-called computer implemented inventions for protecting software in Europe. In the United States, of course, you can protect software per se via patent. But in Europe, we are more strict for protecting this solution. Normally, it's copyright protection, which is not mandatory to register, as you know. So but we have alternative. We have specific patterns for software in Europe too, but this is very granular cases when we can really justify the technical elements of your software. Okay, should be assessed. Should also be part of the strategy. Also, for hardware patents, if does not work for your case, can be utility models, can be design rights, or also NDAs for trade secret protection. For brand's reputation, of course, trademarks, design rights, and copyright. Also for mobility as a service, detecting IP assets, all these databases, all these apps. So any commercially valuable information that you possess that's already IP asset that can be and should be protected. Compilation of information, website interface, and content assembly. Technology and algorithms. Also, we have, as all you know, AI regulation in Europe. So, and it's aligned with Horizon Europe requirements too, with regard to proposals. So, if your solution has any AI elements or your AI algorithm is the core for your solution. So good practice, that's basically requirement for Horizon Europe regulation to explain the functionality of your solution. Explain how, so basically that's the transparency principle, right? So you must be transparent, you should explain how your algorithm is working, tech robustness, accuracy, social robustness, trustworthiness. Yeah, so that's all lead to these principles of trustworthy AI system. Can be protected. Algorithms, right? They can be protected. Some cases even by patents if it's technically related or computer implemented algorithm. But always by copyright, utility models, design rights, and these they always can work for algorithms too. And brands' reputations always do. And if we look at the requirement of drafting of IP strategy, if we approach the strategy, we should look at in a proposal, of course. So evaluators look at your proposals and at your IP strategy through the assessing the measures that are maximizing the impact. Okay, so you must illustrate these measures. So what protection measures are you implementing to protect your solution? What exploitation measures you will implement? It should be comprehensive, it should be feasible, of course, and also be aligned with the outcomes, with your business plan, with your expectation from the from commercialization of this solution. So if we look at your proposals through the lens of evaluators, right? So that's basically thinking beyond the project. Okay, so not only focusing via this project, but basically going to the market and how are you going to monetize these afterwards. Also uniqueness of your solution. So how is your solution different from other on the market? That's important in terms of IP strategy. That's part of your due diligence, right? Assessing your competitors will help avoiding IP disputes in future or during the project and also maximize the leverage from the investment that you are getting, and will give you more broader view on the plans that you will have, like licensing, access to finance, and finding investors and partners. So if we look at the requirement freedom to operate, so why do we need this? Once again, that's the part of smart best practice to assess your solution and compare it to the existing in the market. It's also the part of pattern analysis if we are talking about inventions. So it's what is the scope of your solution, right? So which geography, in which geography it will be unique. So what jurisdiction are you going to cover? So what is freedom to operate? That's basic research. That's the report on the search that you conducted with regards to comparison on your on competitors, on identical or similar solutions that are in force or still valid, right? So why? Because we need to understand whether you will be able to implement your solution in the market. So if competitors can basically stop you, right? Once again, we are funding solutions that are close to market, not abstract proposal, right? So that's the part of this approach. In terms of patents, FTO works in a way that it provides the general landscape, the general picture of the existing solution in the specific markets and how you are going to commercialize them and how you're going to dive into this market within this existing solutions. So if we the main point that you cannot ignore others. Yeah, why? If you have very narrow proposal, right, like H2 carbon bicycles, and we have patents for all bicycles, let's say. Yeah? So in this case, you could be prevented to enter to the specific markets by the holders of all bicycle patents. Yeah? This description from FTO will help you to understand whether you can redraft your solution, or probably you can redesign the product or technology, or you should switch to another market, or you must license or cross-license or partner with your competitors, or sell or wait. Yeah, so maybe their patents will expire soon. And so that's the part of due diligence. And in the terms of the call, of course, we have this extra KPI which will need to meet delivering this report on specific stage. And drafting your proposal, that's section 3.5. So brief this, you basically need to explain in brief your technology, an important title and ownership on this technology, because generally speaking, just mentioned that we should understand the ownership, whether that's the company or that's third party who is owning, some inventor who is owning the technology. And in this case, you must provide the justification that the transfer was made from this inventor to the company, and the company will receive funding to implement this solution. Also, legal status, so registered patents or only applications also work, but you must identify this. Or you decided to go for secrecy, so you should also explain the strategy, why you're deciding for secrecy and what measures are you implementing. And of course, commercialization, so obstacles to risk assessments. And for that, of course, we have specific points for all of these elements. and bad practice and good practice. So bad practice, basically generalization. So providing third-party solution without authorization, bad practice, right? Um, so intention to pattern versus claiming to have a pattern. Yeah, so don't confuse anybody with the pattern or pattern application or intention to pattern. Yeah, so be specific. Just detect the main IPR they are going to receive, that you are going to apply, or you are actually possessing already. Justify commercialization and impacts of your solution. And so basically due diligence and cost benefits and licensing and transfers and partnership, that's all should be of course we have very small capacity in the proposal to explain that, but being specific will help you to meet these requirements. Well, I believe that's all from my side, and for any other queries and questions, of course, you can reach out via specific this email that we have here for any questions during your IP strategy drafting. And thank you. I would like to have this opportunity to just to mention our innovation advisory services support that we also give to our startups with relation to IP and strategy questions and drafting your IP proposal, IP strategy.
So if you have any questions at this stage already for the proposal, please let us know. We will, I mean, it's in our benefit to help you. And then when your proposal is selected during the project, you of course also can get support from our side. We can close this webinar. As I said before, this webinar was recorded and we will upload it on the call webpage in case you would like to. I mean, it was dense, it was a lot of information. So thank you very much, Mai, was super useful. Feel free to watch it if some things were not clear. As I said before, reach out to us if you need something. And that was it. This was the last webinar in a row of 3. Good luck with the applications, and we are here for you if you need any help. Bye-bye.
Good luck, bye. Thank you.